come back on the record with the examination of Mr. John K. Coyle. Let's go ahead and proceed. I think you're about to finish your direct examination.
Almost, Your Honor. Mr. Coyle, I want to go back and establish the time frame that you were imprisoned, incarcerated. I'd earlier shown you an exhibit at the amended, it's Exhibit 4. I'll go ahead and bring it up. Oh, Your Honor, can you have John?
I need to enable it.
Yes, sir. As well as Mr. Evans, Evans Crow wants to listen in.
Oh, that's right. It'll enable it for all participants.
Okay. Mr. Coyle, do you see the exhibit? We earlier talked about this last week. Exhibit 4, it's the amended judgment in a criminal case.
Yes, I see it.
All right. And I'm just showing this for purposes of establishing the time frame when you were incarcerated. This is dated file stamp May 21st, 2009. And I'll represent to you, it's signed by Judge Hudspeth on May the 20th, 2009. You see that?
Yes, I see that.
Okay. And then the next page talks about imprisonment. And so you were sentenced to 33 months as to count 9 and 60 months as to count 23. The sentence imposed on count 9 is to be served concurrently with the sentence imposed on 23. And it goes down, the last paragraph says that the defendant shall surrender for service of sentence at the institution designated by the Bureau of Prisons at or before 2 p.m. on Tuesday, May 29th. It says 2007, but I'll submit to you that's probably a typo since this was signed on May the 20th, 2009. Do you believe you reported to prison in May, late May of 2009 to serve your sentence?
No, I believe it was January of 2009. So
January of 2009?
Piece of paper where your arrow is, May the something 2007 is probably inaccurate, and probably
correct.
The judge's dating is right.
So the judge signed the amended judgment in a criminal case on May the 20th of 2009. And I'm sorry, when did you start serving your sentence?
No, well, first off, I have a poor memory. I thought I was there from 9 to 13, and I have it written down, but I don't have it in front of me. And I thought it was January of 2009 to May of 13.
Okay.
So
that's
my remembering, not what the judge wrote.
Okay. And during that time, you did not have access to the outside world, did you?
No, I didn't.
Other than people coming to visit you? Is that correct?
Yeah, a few people came visit.
I'm sorry?
Yes.
Right. You did not leave prison during that time. Is that correct?
Yes, I did not leave.
And you did not have access to your records and prepare records during that time frame, did you?
I did not.
Okay. Let's go to Exhibit 34. Your Honor, Plaintiff's Exhibit 34 is the affidavit for business records of Fidelity National Title Insurance Company, who is a related entity to Chicago Title of Texas, Inc. When we filed this affidavit of business records back in January of this year, and I'm requesting admission into evidence of this business records affidavit, as well as the attached pages 1 through 380, bait stamp Chicago Title 1 through Chicago Title 380.
Any objection?
Only that, Your Honor, there appears to be some records in there that are not business records. It's about 300 pages, and most of it are business records of Fidelity National Title Insurance Company. But there are records interspersed in there that have nothing to do with the business of Fidelity National Title, and clearly are not records with notations made thereon by someone that she can testify had personal knowledge at or near the time of the occurrence, and clearly are not records that are made in the regular course of business of Fidelity National Title. So I don't have an objection to the entire thing, just selected documents out of there. And maybe what we can do is Mr. Donahue can go to specific pages he wants to have admitted, and we can look at those.
I am, Your Honor, going to go to specific pages, but at the same time, I'd like admission of the entire business records affidavit that's proven up by the by Fidelity National Title.
Exhibit 34 is admitted.
All right, let's go to Exhibit 41.
Wait, you admitted the exhibit, but you didn't go through it at all?
Well, this is part of the exhibit. I am going to go to specific documents that are within that exhibit, Your Honor. I
And
think
this is Exhibit 41?
This is Plaintiff's Exhibit 41, which is part and parcel of that affidavit. I just separated, just made a copy of it.
All right.
It's bait stamped. Plaintiff's Exhibit 41, go toward the bottom, is bait stamped Chicago Title 366. You see that? You see that, Mr. Coyle?
Yes.
So that's part of Chicago Title's records that they submitted with this affidavit. Do you understand that?
Yes.
All right. And Plaintiff's Exhibit 41 appears to be a letter on AVE Inc. stationery at your office address on Wood River in Illinois, dated September 30th, 2020, to Jennifer Peterson at Chicago Title in Austin. You see that? Can you raise it some? I'm sorry. Raise it to the addressee. All the way. Yes.
I see it.
Okay. Do you recall dealing with Jennifer Peterson at Chicago Title in Austin?
No, I don't recall.
All right. And this is a letter which is signed by you. Is that right? That's your signature?
That's my signature.
Okay. And in the third paragraph, you state, enclosed are the corporate record books of AVE Inc. and Bocanon LLC. You see that?
Yes.
All right. So this is where you submitted that certificate of formation that quite frankly was a fake. You recall that?
I don't recall it, but my assumption is yes.
Are you talking about Exhibit 32?
I am talking about Exhibit 32, Your Honor. I was going to go flip back through it, but let's show the witness Exhibit 32. Okay, and it's bait stamped Chicago Title 222 through Chicago Title 225. You see that at the bottom right?
I see that.
All right. So this certificate of formation for Bocanon, this is what I called it the fake, for lack of a better word, that you submitted to Miss Peterson at Chicago Title by way of that letter, Exhibit 41, correct?
I was trying to pay off $1.2 million loan that my son borrowed from a hard money lender at 16% interest that he put up a lot of pieces of property.
Objection, non-responsive.
A deal where they
objection, non-responsive. I don't know.
Overruled. You can answer.
I was going to add $300,000 to it and pay off this money where these people were swindling my son.
All right. My question, Mr. Coyle, is by way of Exhibit 41, that cover letter you sent to Miss Peterson at Chicago Title, you submitted this fake certificate of formation for Bocanon, correct?
You're accurate. I did.
Let's go to Plaintiff's Exhibit 42. Go to the bottom. Where's the page stamp? On the first page. And this is Bates stamped Exhibit 42, Chicago Title 351. Through 356. Do you see that at the bottom right? I'll represent to you. It goes all the way to Chicago Title 356.
I see Chicago Title 351.
And this is what Chicago Title had in their files by way of apparently investigating you as far what the U.S. Attorney's Office had submitted in the way of a release about you. Correct?
That looks like it.
And the first page of Plaintiff's Exhibit 42, the last paragraph, I'm going to read it in part. On June 11, 2004, Coyle of Highland Village, Texas, pled guilty to, and it goes through, number 2 is mail fraud for mailing a fraudulent 1040 tax return in furtherance of a scheme to defraud the IRS. Coyle also agreed to forfeit all his enterprise properties within the state of Texas. All of that was correct. Isn't that right, Mr. Coyle?
We've had this discussion last week.
Was that a correct statement by the U.S. Attorney's Office when they released that information about you?
Yes.
Let's go to Plaintiff's Exhibit 26. Plaintiff's Exhibit 26 is defendant's response to plaintiff's first set of interrogatories to defendant John K. Coyle. You see that?
Yes.
All right. And turn with me, if you will, to interrogatory number 3 on the 3rd page. And it states, interrogatory number 3, state the consideration paid for that certain general warranty deed dated February 27, 2015 between Yang Chu as grantor and East Bay. And your answer is the @ 2.125 million. You see that?
I see that. Didn't we just
On the last page of these interrogatories?
Didn't we just testify to that a while ago?
On the last page of these interrogatories, is that your verification, Mr. Coyle?
Yes. Mm-hmm.
That's your signature?
Yes.
And then let's go back to, I'm sorry, interrogatory number 4. State the consideration paid for that certain warranty deed dated December 7, 2018 by John K. Coyle as president of East Bay as grantor and Bill Wilson as grantee, where East Bay purportedly granted solely conveyed to defendant Bill Wilson the Anaheim Drive property, including stating, number 1, the total amount of such consideration, number 2, the identity of the person or entity that paid such consideration, and number 3, the identity of the person or entity who was paid such consideration. Your answer, a defendant objects to this preceding interrogatory as it's overbroad, burdensome, and constitute harassment. Defendant objects to the preceding interrogatory as it exceeds the permissible scope of discovery because it seeks discovery material that is not relevant to the subject matter of the action or that is not reasonably calculated to lead to discovery of permissible evidence. And at the end, you say defendant objects to this interrogatory as it seeks information which the defendant is protected from disclosing by the Fifth Amendment rights under the U.S. under the U.S. Constitution. Did I read that correctly?
Yes.
And is that what you're invoking, is your Fifth Amendment right not to answer the question as to the consideration, if any, paid by Bill Wilson to East Bay?
Yes,
All right. And interrogatory number 5, state the consideration paid for that certain warranty deed dated August 12th, 2019, between Bill Wilson as grantor and defendant AVE Inc. as grantee, whereby Bill Wilson purportedly granted, sold, and conveyed to defendant AVE Inc. the anion-derived property, including stating, number 1, the total amount of such consideration, number 2, the entity of the person or entity that paid such consideration, and number 3, the identity of the person or entity who was paid such consideration. Your answer: defendant objects to the proceeding in interrogatory as it is overbroad, burdensome, and constitutes harassment. Defendant objects to the proceeding in interrogatory as it exceeds the permissible scope of the discovery because it seeks discovery of material that is not relevant to the subject matter of the action or that is not reasonably calculated to lead to discovery of admissible evidence. Defendant objects to this interrogatory as it seeks information which the defendant is protected from disclosing by his Fifth Amendment rights under the U.S. Constitution. Once again, Mr. Coyle, do you stand on your Fifth Amendment right, invoking that as far as not disclosing what, if
Yeah.
any, consideration was paid in that warranty deed?
yes.
Is that a yes?
That's a yes 3 times.
All right. Number 10, we're looking at interrogatory number 10. State the telephone number, cell number, mail address, home, and business and mailing address of defendant Bill Wilson. Answer: unknown at this time. The address that you hand wrote in for Bill Wilson in Illinois was not his address. We've established that, correct?
Yes,
That, in fact, was your address, correct?
yes,
And you don't know the address, phone number, cell number, or contact information for defendant Bill Wilson. Is that the case?
yes.
Was that the case as of the time of the dates of these warranty deeds?
He comes through. He calls me. I don't call him.
Okay, but even then, you did not know his address, his phone number, his cell number, or how to contact him. Is that correct? Is that your testimony?
He's paranoid.
Pardon me?
We use the phrase paranoid to describe the plaintiff in this action. He is paranoid. My son is paranoid schizophrenic. I don't know that Bill Wilson is a schizophrenic. I just know he's paranoid because of the nature of his business.
The reason that you called your wife in October of 2019 to ask if she knew of a Bill Wilson near her is because there was no Bill Wilson associated with these warranty deeds, correct?
No, my ex-wife is lying. When she abandoned the family, I need to correct that. She took the 3-year-old and the girl. She left my son, John Altar, the plaintiff, in a big house in New Mexico by himself, and she went to Mississippi with the other 2 children, abandoning that child.
Objection, non-responsive.
Pretty
Same.
responsible, in my opinion.
Mr. Coyle, my question is that the reason that you called your wife in October 2019 and asked her to check the phone book, local phone book, or the library records to see if she could find a Bill Wilson, which is a pretty generic name in her area, was because there was no Bill Wilson that entered into those general warranty deeds that we've gone through on Forest Lane property, correct?
She lied. She only did that because the plaintiff was paying attention to her where he had not seen her for decades.
And the reason you don't have an address or phone number or any contact information for Bill Wilson is, once again, because he's a non-existent person as far as those general warranty deeds are concerned, correct?
No, Bill Wilson's real.
I'll pass the witness.
Any cross?
Yes, sir, Your Honor. All right. Mr. Coyle, if you could you tell the court, how did you get involved in this business, the adult entertainment business?
I was representing a guy named Jerry something Buchanan. I was practicing law in Dallas, and I started representing Jerry Buchanan. He had a theater on Industrial there in Dallas, and so he had an employee named I'll think about it in a second. Anyway, he came to me and said, let's open a store on, it wasn't a store, it was a theater. Let's open the theater on Cedar Springs. And so he did, and I was a silent partner.
And what year was this?
Oh, it had to be 71.
Okay.
And the name of the theater was Cinema 69. Then we opened the theater in Abilene. I think it was on Treadwell. Shortly thereafter. Let me think. Do you need his name?
Doug Richards?
Dick Hayes.
Dick Hayes.
Then, yeah, that was in 71. And then Dick was living with this lady who was the wife of a policeman. And she had a boyfriend. And other than Dick Hayes, I don't know if the judge wants to hear these stories or not, but.
Well, why don't we just stick to your involvement in this adult entertainment business?
At any rate, I was no longer involved with him because of he was killed, maybe by the policeman, maybe by the boyfriend, but the boyfriend is the one that ended up with the stores. So then the next year, Doug Richards, who was also a client of mine, we incorporated Heritage Antiques and we started operating stores. We operated a store in Fort Worth on Main Street. We operated a store in the mid cities next to a topless bar. I think it's 157, Highway 157. And we had one on Harry Hines, and we had a number of them. We had the first ones in Houston, 8213 Gulf Freeway, and we built a chain of these things.
And as part of opening those kind of stores, do you have to have a special license from the city?
No, at that time, the city didn't know what was going on. These weren't stores, they were theaters. They had theater seats in them. We bought the theater seats used from SMU.
Your Honor, I'm sorry to interrupt, but my client just pointed out to me that the upper left-hand corner shows live on YouTube. I thought that was a situation that the invocation of the rule was supposed to preclude.
Yeah, we did discuss that. Did you guys want me to take this off of YouTube?
We do.
Yeah, that's